Call the second case on this morning's docket. Case number 117850, State of Kansas v. Michael Ross.
May it please the court, Peter Meharry for Michael Ross. If I could have 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes before this court after his conviction, Mr. Ross's conviction for 1 count of felony murder and 1 count of child abuse. Those charges arose out of the death of a young child back in, I believe, November of 2015. At that time, Mr. Ross lived with his girlfriend. She had 2 young children, and when she would go to work, Mr. Ross would watch the children. In November of 2015, started out as an ordinary day. Mr. Ross's girlfriend did go to work. Shortly after she was at work, she received a call from Mr. Ross who stated that her youngest child was unresponsive. She returned home. The child was unresponsive when she got home. Paramedics were called. They arrived, took her to the hospital. Ultimately, the child passed away. Medical professionals in this case testified that she suffered from several injuries, including a subdural hematoma, as well as a lacerated liver, as well as bruising around the body. From that, the state charged my client with felony murder, with the underlying felony being child abuse and an additional child abuse charge. We've raised 4 issues, one of which is cumulative error in this case. What I'd like to do is start with the 3rd issue, then circle back around to the first issues. The 3rd issue deals with the admission of jail calls between my client, Mr. Ross, and his mother. Those jail calls have been added to the record on appeal for the court to hear, and I would urge the court to listen to those again.
Well, I listened to them. What's objectionable about that? What's the basis of your objection here? Isn't that just part of evidence in a case when you have to determine credibility of witnesses and statements of witnesses? It was a conversation that was pretty detailed and graphic, but isn't that part of what happens in these cases?
Yeah, and I think the problem is the sheer emotion of my client's mother in those calls. She clearly is showing between her tone and tenor.
Well, she's questioning him and outraged by what happened.
She is outraged by what happened, and she's also clearly not believing my client. And I think she is acting, when you put that in front of the jury, she is acting as a human lie detector test for that jury. And if the mother reacts that way in total disbelief as to what her son is saying, I don't think her son has any fair shake when he gets on the stand and testifies. His credibility is already shot because of her tone and tenor.
So it's prejudicial, but what's the legal theory that you use to say that that where evidence is relevant? Often we make the comments that sometimes the worst facts are the most relevant, but they're also prejudicial because they are the most relevant. I mean, they do the most harm to the defendant's case. Anyway, so what is the precise legal theory that would cause this to stay out? Is it that more prejudicial than probative?
It's that the prejudicial impact of this is so heavy, it just swamps any minimal relevance or probative value that this evidence has.
And that standard of review is abuse of discretion?
It is abuse of discretion. And I think when you look at the weighing of probative versus prejudicial here, the state wants to argue that these show additional inconsistent statements of my client. Mm-hmm. They had already put on medical professionals who testified to his statements, his girlfriend who had testified to his statements, the interview by the detective that included his statements, as well as eventually his testimony, as well as letters he sent, all including those similar inconsistent statements. That had all come in already before these calls.
Wasn't there a jailhouse
In addition, a jailhouse snitch testified as to what my client purportedly told him in jail, which were additional inconsistent statements.
Weren't some of the statements he made to his mother on the calls also inconsistent with all of the above? I didn't come up with at least one more explanation.
I guess I'd have to double check. I did not
Okay.
think so. I thought he was restating prior inconsistent
So the
statements.
reason you characterize these statements by him on the tapes as minimally probative is that you think they were cumulative of evidence already?
They did not add anything to trial that the jury had not already heard. What they added to the trial was his mother basically accusing him when she says, "Tell me you did not lay your hands on that child." And there were explicitives mixed in there. And she was yelling at her son in a tone of disbelief. And I don't think he can recover from that and get a fair trial in the eyes of the jury when that's in front of him.
I understand you to say that this evidence should have been kept out because it was cumulative, because all this other evidence came in. But then on the other hand, you're saying this particular piece of evidence is so prejudicial, it should have been kept out. I'm having trouble reconciling those two positions.
My argument, Your Honor, is when you look at evidence, you weigh the probative value versus the prejudicial impact. And here the probative value is minimal because it is cumulative. It just is regurgitating what is already in front of the jury. So I think the probative value is basically nothing, but the prejudicial impact is extreme. So when you look at the evidence, why is it being brought in? The state wants to argue it's additional inconsistent statements. That's already in front of the jury. So it doesn't really have any impact for the jury in that regard. But what it does do is taint the jury against my client because they hear the mother yelling and screaming at her son. And I would also note, and this is in the motion for new trial filed by defense counsel, that he talked to the jurors afterwards. And the jurors commented that they believed from the get-go that Ross's mother did not believe a word he was saying, and that they wondered if he had done something like this in the past. So this did have an impact.
Well, there's that, you said that's in the record?
Yes, Your Honor, that's in the motion for new trial. I believe it is volume 1, page 211.
Don't the tapes also, though, just give the jury the sense that, here's story one, oh, mom didn't believe that, let's add another fact here, oh, that wasn't enough, mom didn't believe it, so let's add another fact, another possible scenario, and see if that flies. I mean, is there, to me, that is very probative of the state's theory that he was just changing his story to, as he got more information about the severity of the injuries and knew that he had to bring in more accidents to account for all of the things the medical conditions.
I guess, again, I don't see it that way as having that almost inherent probative value within this call. I think all of that evidence as far as him changing his story is already out there. You don't need the phone calls for that. But again, what you do get with those phone calls is his mother not believing him and putting that in front of the jury, which I think is overly prejudicial.
Is there any reason other than the prejudice you're arguing why that evidence should be inadmissible? The fact that the mother didn't believe him?
Our argument is that it was overly prejudicial, so it should have been excluded, Your Honor.
Nothing, I mean, so otherwise it's admissible and relevant. It's just the fact that it's prejudicial.
We recognize it is statements of my client, so there is some minimal relevance there. But this court, case law has always said even relevant evidence can be ruled inadmissible if it is overly prejudicial. I think this meets that standard.
And the particular factor that we've looked at as far as an abuse of discretion that you're relying upon is that no reasonable person would have agreed at the trial court?
That is what we're relying on, and I recognize that is a high standard, but I think when you listen to the phone calls in this case, the tone and tenor of his mother just cannot be overcome such that it denied him a fair trial in this case. Moving back to the first issue, which deals with the prosecutorial error, we have asserted that during closing arguments, the prosecutor misstated the law when he argued, quote, "Did you really believe the defendant's testimony? Ask yourself, is an unconscious baby going to be able to hold her ribs? What did you believe of his testimony? Because if you didn't believe it, you must find him guilty." And that's from volume 17, page 208. It's our position that that is a misstatement of the law. And this court has said, going back to Pabst, that a jury can disbelieve a defendant and still acquit. That does not mandate a conviction. The state still has to prove their case.
Can we put this into context, because you're picking this out? This was stated in rebuttal, and as I read at least defense counsel's closing argument, the whole theory was that this was the perfect storm. In fact, spent a good deal of time talking about the movie as opposed to the case, but talked about a perfect storm, and it was in response to that. It really wasn't so much of this big burden shifting kind of argument that he was presenting. It was just, if you believe this version, and perhaps it was an overstatement about you must, but that was the context in which it was given, wasn't it?
The defense essentially was that this was a tragic series of accidents at the home that resulted in this child's death. But I still think the statement is a misstatement of the law, and I don't think that just simply saying, well, it's response to this statement excuses it. The argument in response is the evidence doesn't support his testimony. And we have proven A, B, and C, the elements of this offense, and therefore you should convict. It's not, if you don't believe him, you must convict. And I think that does shift the burden onto my client to prove that he is believable, that he has to prove his innocence in this regard. And again, that certainly is a heavy burden for any defendant. And in this case, with the outsized role his statements played, including his testimony where they went through all of his statements, I think it's an insurmountable hurdle for him to get beyond.
Can we you're almost out of time, and you have the next issue is the basis of your request for a reckless, and I, as I understand it, is first, counsel, no one wanted lessers in this, and then the court said, no, I think there's some support for second degree intentional, and gave that instruction, and then Mr. Ross then requested reckless second degree as a result of getting second degree, as I understand what happened. But what you're relying on for this instruction is is it Rapito? He's the jailhouse, who gave several different versions of what Mr. Ross told him. But the version that you're relying on, it just, as I look at it, and I'm taking it from your brief, was that testified Ross got mad, grabbed GH, yanked her arm, threw her off the cabinet, then fell, hitting her head. Ross slapped GH on the legs while playing in the bathroom, again causing her to fall, and then took her to the bedroom where he knocked a TV on her head to make it look like an accident. And how is that reckless conduct? I mean, that's what you're relying on to request the instruction for reckless.
Right.
And how is any of that reckless as opposed to intentional? It kind of overlaps with the first case we had, but
Sure.
So how does that fit with a reckless second degree murder? I was thinking about this, and if I shoot someone 3 times in the chest, well, I didn't mean to kill him. I just wanted to harm him. It was reckless on my part to do that because he died. Well, how is this any different than that?
Well, I think with intentional first-degree murder, the question is the intent to kill, not necessarily the underlying act. And you can certainly say that pushing a TV, that sure seems like an intentional act. But the question is, did he push that TV onto the child with the intent to kill? And one other thing that I think it's Rapito, Ross always denied any intent to kill, even when he was purportedly talking to this jailhouse snitch. He said that he was trying to cover up the fact that he had injured the child earlier. and that he was trying to make everything look like an accident, and that's why he pushed the TV over on the child. And that shows, sure, it was an underlying intentional act, but there's no intent to kill there. And a jury could conclude, well, there was no intent to kill, but that certainly is a reckless act. Reckless indifference to, an extreme situation that could cause, in this case, death. So I believe that is the factual basis that would support a charge of reckless second in this case.
Is that issue rendered moot by the felony murder conviction?
I don't believe so, Your Honor, because they charged in the alternative here, and they charged premeditated first with murder to intentional as a lesser, and the alternative felony murder. Had they been given this additional opportunity to convict of reckless, they certainly could have convicted solely of the reckless and not of the felony murder charge. So I don't think you can just say, well, they convicted of felony murder anyway.
Were they
We don't-
instructed to consider the offenses in a particular order?
I'm not sure, I think they gave the standard pick on it, but I'd have to double check as to how they were instructed to consider it. But I think there is that possibility that they could have convicted of the still lesser, reckless second, if they've been given that opportunity, and would not have convicted of felony murder.
Isn't the felony murder fait accompli once they convict of the child abuse and she's dead?
Logically, maybe, but I think certainly this court has said juries can give inconsistent verdicts. So I think they could have found child abuse and not felony murder, and I don't think we would have been able to challenge that on appeal. And I think certainly this court would have affirmed it. So just because they convicted of child abuse doesn't foreclose the issue of convicting of a lesser on the other side of the tree with murder one and its lessers.
Any further questions? Any further presentation?
No, Your Honor.
Thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. I am going to start with issue 3 regarding the jailhouse calls, but Justice Breyer, before I forget, with respect to the instructions, the jury was instructed to consider premeditated, then second. It wasn't phrased this way, but the way it appeared in the instruction packet was murder 1, second, and then felony murder. The third issue challenges the admission into evidence of the jailhouse phone calls that the defendant shared with his mother. The defendant has recognized some relevancy in those phone calls, but primarily comes before this court with the argument that they should have been excluded because they were more prejudicial than they were probative, and this court looks at that from an abuse of discretion standpoint. And this court has consistently adhered to the position that the exclusion of relevant evidence is an extraordinary remedy that should be used sparingly. The state's theory of the case here was that the abuse to the child was purely intentional, and that the defendant's claim that it was purely accidental was not credible, and used his ever-evolving series of events to establish that lack of credibility. Now, we do not look at this or the argument can't be made that it was necessarily cumulative, because the whole point in the state's case was that it was ever evolving. If it was an accident, as the defendant asserted, then it was always going to be the same kind of accident. But throughout, the defendant gave ever-changing series of events. And those phone calls served to establish that this was just one more explanation that the defendant was giving for why this should be perceived as an accident. So it does not fall into a situation where all of that evidence was already before the jury, because it wasn't. The theory that it was an accident was already before the jury for sure. But exactly what kind of accident he was talking about was something that the state was trying to establish, and the jailhouse phone calls was another piece in the state's case to establish a lack of accident. The defendant does not point any authority to this court that says the state is required to pick and choose from its admissible evidence that it can use in establishing its burden, nor does he cite any authority that he has the latitude to pick and choose what evidence the state is going to present.
We have case law, though, that says, or that where we require the redaction of credibility statements by one witness of another. I mean, the prime example is in confessions or interrogations, that if the detective makes a comment about, well, I don't believe that, we
Sure.
require that redaction.
There was some degree of redaction that occurred to these phone calls. Now, what exactly was taken out, I do not recall. But the jury was specifically instructed on, the court had attempted to strike a balance between the state's right to present its case and the defendant's right to have a fair trial, and said, look, jury, you are not permitted to consider the demeanor, the tone, and the tenor in the course of your deliberations of these recordings that you have listened to. That doesn't factor into your deliberations. So there was an effort to secure the defendant's right to a fair trial while still protecting the right of the state to introduce relevant evidence. The state would respectfully request that that decision be affirmed and that there not be an abuse.
Is that a
of discretion.
tacit admission by the court that this was highly prejudicial? That instruction that you just referenced?
I don't necessarily think that that's overly prejudicial. Is it prejudicial? Yes, because all evidence is.
Well, that goes to, I guess, the follow-up question. We aren't talking about prejudice in the sense that all evidence is prejudicial to the defendant's ability to achieve an acquittal. We're talking about something that's improper, right? It's an improper kind of prejudice.
And that would be
It would encourage the jury to consider something that it shouldn't consider.
when it's overly prejudicial. Yes, I think that's where the overly comes in, is when it becomes
Unduly.
unfair.
I think
Yeah,
it's
or
like
unduly.
Yeah.
But, and I think that's what what we try to balance when we exclude.
But the instruction, the fact that the court gave an instruction saying don't consider certain things about this phone call seems to me to be an effort to mitigate what would be a tacitly admitted unduly prejudicial element of that call.
I think if the court perceived it as unduly prejudicial, he would have gone ahead and excluded it. But I think he recognizes the impact that it can have without seeing that it goes to the next level. But in some respects,
So your
this
argument,
is,
I'm sorry to interrupt, but
No.
just your argument is that there was a weighing that was done by the district court and it was a proper weighing. Your argument isn't that there's no prejudice here.
yeah, I'm saying that the court took the matter under its advisement and determined whether this crosses the threshold into unduly prejudicial, and made the assessment that it did not.
Does the record reflect anything where the judge orally explained his thought process with that?
The record would speak for itself. I don't recall exactly what was said. I do know that the court did that on its own volition. It wasn't at a request by the defendant. In some respects, this really isn't any different than seeing a live witness on the stand expressing outrage or expressing emotion, or, especially in a case of this nature, and that doesn't necessarily make that individual's testimony unduly prejudicial.
But the first call is like the day after the event, but before death, and the second call was like the day after death. So that timing makes it a little bit different than when it got to trial, if that witness had been on the stand.
I do not recall the precise timing of the phone calls. We would then circle back to the first issue, challenging the statement that was made by the prosecutor during closing argument. And this court has a two-step standard of review. It's a consideration of error, and it's a consideration of prejudice. And first, whether the statement falls outside the latitude that the prosecutor is afforded in discussing the case, and then if so, whether the state can establish beyond a reasonable doubt whether that statement had any impact on the verdict. So again, the statement at issue is, did you really believe the defendant's testimony? Ask yourself, is an unconscious baby going to be able to hold their ribs? And what did you believe of his testimony? Because if you didn't believe it, you must find him guilty. And the defendant's argument is predicated upon a very isolated portion of the state's closing argument, and a fair reading of the entire record reflects that the state was attempting to carry forward its theme that it started with in its opening, that when a case turns on which of two series or explanations of events, then the evidence demonstrates that certain testimony is not believable. For example, the challenge statement was not uttered right out of the gates. It occurred 5 pages into the rebuttal closing and followed an extensive summation of the evidence that was presented in a compare and contrast format. While it may not have been stated in the way that we would prefer, the intent behind the statement was that the evidence should lead the jury to its conclusion. But even if the statement in isolation gives this court some pause, the analysis doesn't end there. When we determine whether a defendant's right to a fair trial has been compromised, we look at the entire record and the impact that that statement may have had in light of the entire record of the case.
So you're not conceding error or telling us to assume error and just go to harmlessness. You're fighting whether it's outside the wide latitude because the prosecutor had a pure heart.
I'm saying that if you look at the argument as a whole, that it was part of the proper argument advanced overall, that when you're looking at 2 explanations for the case, that the evidence directs you, or the evidence may establish one of these versions of events is not believable. So our first position is that it wasn't erroneous, but if this court is going to view it as erroneous, it was harmless in light of the entire record. And the support for that would be, do you have a question?
So you're saying the context would let the jury know that when the prosecutor said, if you don't believe the defendant's story, you must convict, didn't really mean what they said, because you would agree that's not a correct statement of the law.
I would agree that's not a correct statement, but my argument would be that was not her intention. When you look at the record, or when you look at the context of the entire closing argument, that was not her intention.
And you're saying the context would make that clear to a lay juror.
Yes, because when you look at the entire argument that they heard, it was continually presented to them as, this is what the defendant is arguing to you, and this is what the evidence has shown. That was
that kind of cuts the opposite way for me, because you presented, here's 2 arguments. You should look at that, and if you don't believe the defendant, then you convict. And what you're really supposed to be saying, if you believe the state's argument, then you convict. Not if you disbelieve the defendant, right? I mean,
yes, and I think if you were to go back and read that in the entirety of the state's argument, it was presented, and this is how we have satisfied our burden. This is how we have established that this was an intentional murder. This is what the defendant has tried to get you to believe. This is how the state's evidence is stronger and establishes that that is the course of events that is
All that just isn't that all just a harmlessness argument? It's an argument why the error isn't prejudicial.
Again, our position is twofold. First of all, it wasn't erroneous because contextually it was an accurate
But you conceded
statement.
that it was a misstatement of the law. I think you just conceded that.
I did. I concede that the
And so-
language makes it.
Well, is it ever possible for a prosecutor to misstate the law and not commit error? That's what you're arguing.
And I think that's what has happened here. I think there are circumstances where a misstatement of the law can be made, and there's no safety net from the context of the argument. Which here we have that safety net. This misstatement of the law does not.
Again, it seems to me that just goes to your prejudice harmlessness argument.
And I guess
Not error. I mean, the first step of the 2-step test is, was there error? And this court's been drawn a pretty bright line that a misstatement of the law is error. It might be a very minor error that didn't impact the outcome, but it's still error. And
Then
if
I
you
guess-
concede it's a misstatement of the law.
I think it's a misstatement of the law, but I think when you have to look at prosecutorial error, you have to look at it in its context as whether it was actual prosecutorial error. You have to look at everything surrounding it. That would be the state's position. To the extent this court does find that it's error, it was harmless in light of the entire record. First off, there was no objection, and while one is not required, it's certainly a factor that can be considered, particularly in this case where defense counsel did not hesitate to enter objections when he was unhappy with the way things were traveling through the course of the trial. Second, one of the last things the state told the jury before the case was given to them for deliberation was go back and review all of the evidence and come to a determination with respect to the defendant's guilt. Further, prior to trial, again, immediately prior to closing arguments, and then in its written form, the court properly instructed the jury regarding the burden of proof, and this court has long determined that it is presumed that the jury has followed those instructions, and we don't have to make that presumption here because the jury actually asked for a readback of the defendant's testimony, which can be interpreted that they were taking their duty seriously, they were weighing and giving careful consideration to the evidence. And finally, there was overwhelming evidence in this case to establish that the defendant intentionally took the life of this child. Considering the isolated statement in light of the record as a whole, it would be the state's position that there's no reasonable possibility that it contributed to the verdict in this case. I am almost out of time, but I will touch really quickly on issue 2, which is the lesser included offense instruction. And again, the touchstone is whether it was factually appropriate in this case and whether there was sufficient evidence viewed in the light most favorable to the defendant as the requesting party to warrant issuing this instruction. Here, I think, Justice Rosen, I think it actually pares it down a little bit more as to exactly what the defendant was relying on to establish recklessness. And it was my interpretation of the way the argument was framed was that he was simply relying on a single statement that was made to Ripito that he knocked the TV onto GH to make it look like an accident, and that the defendant's position was that he did not intentionally kill the child, but that he simply went about a reckless means by putting the TV on top of her to make it look like an accident. In Hegwood, this court added another layer to whether it's factually appropriate to issue an instruction when what you're looking at is a defendant's self-serving statement like we have here. And in Hegwood, it said, when the evidence is overwhelming, a defendant's self-serving statement regarding his lack of intent does not in itself evoke a duty on the trial judge to instruct on recklessness. Rather, whether an otherwise unsupported statement of intent compels a lesser depends on the extent to which the other evidence repudiates that statement. So looking at the evidence adduced here, the position primarily taken by the defendant and consisting only of his statements was that the death sustained by GH, or the injury sustained by her during that short time frame, were merely a series of unfortunate accidents, pure accidents for which the defendant had no culpability. The state's position, based on the physical evidence, medical testimony, and Ripito's testimony, was that the defendant's conduct was purely intentional. The testimony of those medical professionals was that the nature of these injuries could not be a rough and tumble accident, as the defendant described, because they were more akin to the injuries sustained at highway rates of speed. So when the theory is pure accident, no culpability versus purely intentional, there simply isn't evidence of recklessness to compel an instruction.
Let's get back to the foundation that we talked about in the earlier case. What is the culpable mental state applicable? What does it apply to? You say accident versus intentional conduct, but isn't the intent in relation to the death? Intended to kill, or it was a reckless killing? not that it was an accident. It doesn't have to be an accident. It can be an act of child abuse, but if there wasn't an intent to kill, you don't get to second degree or first degree, right?
That's correct. The intent is to the result, which is to kill. But the defendant never argued anything regarding recklessness. There was never any evidence that this was reckless. And the standard is whether there is any evidence from which a reasonable jury could convict of the lesser. Not only is there no evidence, but there's certainly no evidence from which they could reasonably convict. The defendant's position was this was completely an accident. Her death, accident. The state's position, her death, intentional. There was never any evidence adduced to establish that this was a reckless offense other than this single statement that they want to highlight on appeal, that he pushed the TV on her, which he says was reckless now, simply to cover up the abuse that he inflicted. Other than that, there was never any evidence presented that this was a reckless act.
But just to be clear here, if he did intentionally push the television on top of the child with the intent to cover up his child abuse and to argue it was an accident without having the intent of killing the child, that would not, if that were proved to be the case, that would not constitute intentional second-degree murder, would it?
No,
Okay.
but it also doesn't constitute reckless.
Why wouldn't it?
Well, it doesn't constitute
Why
reckless
wouldn't it be a disregard of a high risk there to put a television on a year-and-a-half-old child simply to cover up the fact that you've abused the child? That's pretty reckless to me.
My point
Can I
was.
interrupt?
I'm sorry.
This is not a flat screen monitor. This is an old style TV.
This is a
correct?
70-pound tube TV.
All right, thank you.
Yes. So my point was there's not reckless evidence from which a jury could reasonably convict. I see I'm out of time. If there are no further questions, the state would respectfully request that the defendant's convictions in this case be affirmed.
Any more questions? Thank you, counsel.
I don't really have any additional comments unless the court has questions. I would just.
It's hard for you to answer questions about the pro se, but is it preserved? There was nothing, and I understand that Mr. Ross had about a 50 to 55 minute allocution in which he went on different, but in looking at that, I didn't see where he raised any of the issues before the trial court that he raises in his pro se. In his pro se motion or on appeal.
As far as whether or not they're preserved,
Well, let's do it differently, just not to, so you're not in an awkward spot.
Right,
I mean,
fine.
just because I had the same question, I was about to ask it and I forgot to before. Can you just point to any place where those arguments were raised before the district court?
as far as the arguments raised by Mr. Ross, I can't stand here today and point to something. I would have to go back and reread his brief and look back at the record. I apologize. I don't have that.
I tried.
information for
That's
the
why
court.
I think why we're asking for assistance here. Because okay.
Any further questions? Any further presentation?
No, Your Honor, we would just ask that this court reverse for the reasons stated in our brief.
All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement